Okay, well, I'm gonna get started, everyone. So, welcome to those of you who are potentially listening on the recording. If you have any questions after this, after you listen to the recording, I do have my contact information at the end of the presentation. So make note of that. For those of you who either are on now or will join us, as the presentation goes, please feel free to interrupt me with any questions. I'm happy to answer questions in the middle of it. I obviously can't see you raise your hands, so please feel free to interrupt me and ask your questions, whatever those may be, and I'll get to them. So without further ado, tonight's topic is on guardianships. Generally speaking, I will focus on Illinois guardianships, but I'm also licensed and practice heavily in Iowa. So if any of you are from Iowa or have questions about Iowa guardianships, or in that case, conservatorships, please don't hesitate to ask about Iowa law either. So without further ado, this is what I'll be going over. We're going to start with kind of the basics of guardianships. What is a guardianship, the types of guardianships that are out there, who needs one, and then what is kind of the timeline as far as when you start a guardianship, how long it takes and when you need to start one. Eligibility criteria for guardians themselves. The procedure when a guardianship is always, well, with the exception of temporary ones, is always court appointed. And so there's always a court procedure that goes along with it. We'll talk about standby guardians and guardian nominations, and then kind of finish up with costs of guardianships, and as well as just kind of like a general discussion on the ward or the person, the child, I guess, and their rights under guardianship, and kind of what can the guardian do, what can't the guardian do, what does the guardian have the power to do, and what they don't have the power to do. So moving on. As I kind of mentioned, I'm not going to read the slide word for word for everybody, but a guardianship has to be court appointed. Nobody is guardian of an adult individual without court appointment, and nobody is guardian of a child unless you are the natural parent already, unless you are a court-appointed guardian. So a natural parent is technically not a legal guardian, so to speak. They are the parent and custodian, so they have guardianship rights, but a guardianship is a legal term of art, and it is court-appointed. And they are empowered to make pretty much any and all decisions, substantive decisions for that individual's, depending on what type of guardianship it is, either their healthcare decision-making or their financial decision-making. And we'll talk about the differences as we move on. The important thing about guardianship is that a guardian's decision-making, this goes into the powers and rights of both the guardian and the protected person of the ward, is that all decisions made by the guardian must be in the best interests of the child or the ward. And the guardian always has to be thinking what's in their best interest. The guardian can't just make decisions based on what's easiest for the guardian, what's in the best interest of the guardian, and maybe what's the least expensive option for the guardian. It must make decisions, or least expensive for the ward, but it must make decisions on what is in the best interests of that ward. Okay, so guardianships. There are plenary, or in other words, which is another word for permanent. Permanent guardianships, there is guardian of the person. Guardian of the person is generally for healthcare decision-making. So, what doctors does that person see? What procedures will they have or do they need? What medications will they take? So when somebody who is not under a guardianship goes in to see as a doctor, the doctor and that individual have a back and forth. They discuss what their treatment should be like, what kind of prescriptions they need to be on, that kind of thing. Essentially, that discussion, other than how do you feel, or to the extent that the ward can answer questions as far as their well-being, their current health status, things like that. Obviously, that is the ward's right to answer those questions. Essentially, the conversation as far as what is going to happen in that person's healthcare, in the ward's healthcare, in the child's healthcare, that conversation happens between the guardian and the doctor, almost like a parental relationship when you've got a younger child with a parent and a doctor. It's generally the parent and the doctor discussing the healthcare options for that child. It's very similar with the guardianship. Of course, especially with an adult guardianship, that ward can and should answer questions about their current health status and how they feel, things like that. And then you've got guardian of the estate. Guardian of the estate, also called in Iowa, it's called a conservatorship. But guardian of the estate is financial decision making. Many times the guardian of the estate is not necessary. A lot of times people will, for whatever reason, decide to apply for guardian of the estate at the same time they apply guardian of the person. But if it's not necessary, then you shouldn't apply for or get court appointed as a guardian of the estate. Guardian of the estate is for somebody who cannot make the decisions on their own as far as their financial decisions, but also somebody who has assets. So if we're talking about a disabled individual who has no assets and maybe the only income is Social Security income, which is very common, then an individual is already designated as a representative payee with Social Security and pretty much has control through that representative payee responsibility and power to handle all of that individual's financial decision making. So, be careful when you think you need both guardian of the person and guardian of the estate. It's very possible that guardian of the estate is not necessary, and then you're actually, spending more time, energy, money, attorney's fees, completing and filing the annual report for guardian of the estate when one is not necessary. In addition, there are many times bond requirements with guardian of the estate, depending on how much assets the individual has. Usually, if they don't have any assets, there's no bond requirement, but that also kind of tells you that a guardian of the estate is not necessary. So just so you kind of know the two differences there. Financial decision-making rights of a ward, generally speaking, they're probably a little less than the healthcare decision-making. It obviously depends on the individual's level of capacity to understand their financial situation, to understand what assets they own. And if they do, then they can certainly assist and should assist the guardian of the estate with whatever financial decision makings they make. The guardian of the estate and of the person should always listen to opinions and thoughts from the ward or child or disabled individual in regard to what they think is best. Now, if that person has a guardianship for a reason, and they've obviously been adjudicated by a court that they can't make all decisions in their best interests. So just because a ward tells a guardian, I want to do this, that doesn't mean that the guardian has to do that. But they should be heard and their opinion, and they have the right to have their opinion at least enter in to the decision that guardian is making. So keep that in mind. Other types of guardianships, limited guardianships. All guardianships have either basically a guardianship by default has very broad powers to make almost any and all decisions on behalf of that ward. The ward kind of loses their rights to sign contractual agreements. They kind of lose their right. They don't lose the right to do estate planning, things like that, how their property will be distributed eventually. They can do that. It could be contested later on if they're very severely disabled, but they have that right. But generally speaking, contracts and, again, medical decision-making, signing documents for waivers for doctors or for surgery, all that is done by a guardian. Well, a limited guardianship, and a lot of times, actually all the time, the court is will ask the attorney or the guardian themselves if there's any way that they can limit the guardianship. Are there certain decisions that that ward can or cannot make? And if there are decisions that the ward is 100% able to make, then they can limit that guardianship. If the court determines that the individual is perfectly capable of casting a vote for, you know, a political vote for president or congressperson, then you can limit the guardianship to continue to allow that person to vote. Same thing with if, you know, if they have the ability to handle a small amount of money. You know, you can limit the guardianship in the orders. You can limit them, and they can still have a bank account in their own name, not in the guardian's name, in their own name that they can handle. And the guardian will be able to put money into that account, and it limits the guardian's power to dictate every dime that ward can spend. So limited guardianships are always a consideration for every guardianship. The court always wants to know if and how can a guardianship be limited. So that's a type of guardianship. And then temporary guardianships, we'll talk about these more later on, but there are ways for the current guardian or even parents in some instances to provide a temporary guardianship even without court approval for a limited period of time, in this case 60 days, or in Illinois' case 60 days.
And around the corner.
So, you know, keep that in mind as far as temporary guardianships are concerned. And you know, temporary guardianships are important because if you can get away with doing something temporarily and just, if you just need a short-term solution, you should always do that, excuse me, because, you know, as we'll talk about, you know, filing with the court and going through the court procedures takes time, it takes money, it takes attorney's fees, it takes court costs, all those things, and they add up. So to the extent that you can do something temporarily, not always an option, obviously, but, you know, it should be looked into. Okay, who needs a guardianship? As we've discussed, there are guardianships for minors and there's guardianships for adults. A minor requires a guardian if both of their natural parents or adopted parents obviously don't have to be guardians because they have those parental rights as well, obviously. So any parents who are deceased, if those parents are disabled, or if the parents lose their parental rights, you know, through something happening, then that minor must have a guardian. A minor always needs a guardian. If they can't get a guardian, that's when they become what we talk about as far as ward of the state. And they'll need to go into, you know, foster homes or group living or something to that effect. But if there's ever a parental void, then a guardianship for a minor is necessary. And in Illinois, the age of majority is age 18 when it applies to guardianship. So keep that in mind. Also, a guardianship of the estate is needed in Illinois if a minor, even if a minor has a parent living, if one of their parents is deceased and that parent is deceased because of an accident and there is a settlement that goes along with a wrongful death claim or something to that effect, that structured settlement is going to require the appointment of a conservator to ensure, to monitor the structured settlement, to make sure, to sign all of the structured settlement documents. There needs to be a conservator in place to do so. And so a guardianship, a court-appointed guardian of the estate is necessary to the extent that a minor has either a current windfall or a future windfall in the form of a settlement agreement or a structured settlement. Adults require a guardianship when they are physically, mentally, or developmentally disabled. That can be due to a lifelong disability, or it can be due to a recently adapted one, such as dementia or something else that affects that individual's ability to make any decision. the court will require one of two things. Generally speaking, they'll kind of want both, especially in Illinois, they want both, but if they get one, you can sort of get the court to waive one of the others. But they're either going to want to have the disability determined by a physician or clinician, or the court, the judge, him or herself, is going to want to meet with and determine on their own, whether the individual is in fact disabled. And if it's not, they'll require both. If it's not, abundantly clear that the individual is completely disabled to the point that a permanent guardian is required. So it's always good, generally speaking, disabilities, whether it's a lifelong one or a recently, one who's been recently disabled, there's usually a physician document or diagnosis with that. And so that will need to be filed with the court, showing that that adult requires a guardianship due to a disability. Old age, mental illness to an extent, mild, moderate, even moderate mental illness, somebody who has bipolar disorder that is being, that is controlled by subscription medicines that they're taking, that's not going to be sufficient, at least for a broad, permanent guardianship. The court will likely not find that to be a sufficient reason. Or even a developmental disability without, that clinician report, unless it's abundantly clear to the court. And still, even then, depending on the judge, they'll still require it, that physician's report. So, okay, moving on. Timing, we kind of talked about this as far as the age of majority, but it's important to know if you get if a guardianship is appointed with a minor, nothing really needs to be done to terminate that guardianship. The guardianship automatically terminates at the age of 18. So for example, if you are not the natural or adopted parent of a child whose parents are passed or disabled, and you become a guardian of that individual, that guardianship automatically terminates at 18. Now you can apply, you can file paperwork and get everything kind of set up before they turn 18 and then schedule the hearing for their 18th birthday. But you will need to get a second guardianship if they still require a guardian, I should say. So if it's a disabled child that will be disabled throughout their lives, then once they turn 18, the minor guardianship terminates and an adult guardianship needs to be commenced. So that person will actually have two court proceedings to get their guardian approved. Now, the adult guardianship would be almost a rubber stamp. I mean, if the person has done a good job as guardian while the disabled individual or the child was a minor, and the court's satisfied with the job that they did and the reports that they filed throughout the years, the court is not going to have any problem extending that guardianship. But nonetheless, there does still need to be a court order specifying that the guardianship continues through adulthood. If an individual doesn't need a guardianship, say it's a disabled child, and their parents were alive and well during their childhood, the parental rights extinguish, they terminate at 18, period, dot. There's no right for a parent to take an 18-year-old disabled child into a doctor's office and approve a surgical procedure. Not possible. If the doctors are paying attention to the person's age, the minute they turn 18, the doctor has to stop listening to the parent, unless, of course, there is a guardianship in place. So it's important for parents who haven't dealt with guardianship as a minor, as when their child's a minor, to, contact an attorney, probably a few months prior to the individual turning 18, so that things can be, the wheels can be put into motion and the guardianship can be placed as close to the 18th birthday as possible. Illinois and Iowa, as just a matter of point, do these differently. In Iowa, you can actually get a guardianship approved up to 6 months before an individual turns 18. So you can get it in place. Now, it's not going to be activated until the individual is 18, but you can have it in place so you can be assured that on the child's 18th birthday, the guardianship is in place. In Illinois, the court is very clear that they do not have, quote unquote, jurisdiction over the matter. A district court, not a juvenile court, so the minor guardianship is in juvenile court, but the primary court, the district court, does not have jurisdiction over that child's guardianship until they are 18. So you cannot go into a hearing to get a judge to sign off on the guardianship until that individual is 18. There's no upper age limit for adult guardianships. You know, if an individual, for example, if an individual is 95 years old and develops dementia at that time and needs a guardian, you know, there's no age limit. So we kind of talked about, so for guardians, we have not talked about this. For eligibility criteria for guardians, a guardian does need to be an adult, age 18 in Illinois and Iowa for that matter. They must be a United States resident. They must be sound-minded. What does that mean? It basically, it means they can't, for one, they can't have a clinician or a doctor's diagnosis that they are not of sound mind, that they have some kind of severe mental illness or even moderate mental illness, that they are not disabled. A guardian cannot be a disabled individual. Physically disabled, yes, but a mentally disabled individual, they cannot be. So no felony convictions. Felony convictions can be waived. Many times, you know, an individual who is perhaps a parent and maybe the only option of a child who's turning 18, and that parent has in their past had a felony. It's been, in my cases, it's been waived. I've seen it done, and courts will readily waive that. The only time it probably wouldn't be waived is if obvious felonies that involve abuse of an individual, either financial or physical abuse. Those kind of things would almost certainly not be waived, and there'd have to be some kind of an alternative to that person. But most other felonies can be waived, or any other convictions. You can't have a public agency or not-for-profit act as a guardian. It also doesn't necessarily have to be even a public agency or not-for-profit. If there is a third party out there, you know, say you have the only option is an aunt and uncle who lives far away. The disabled person is in a group home, very comfortable, very happy with where they're at, and the only option is an aunt and uncle that lives far away. There are third-party either private companies. There are pro bono people who do these pro bono and things like that. And that's sort of along the lines of a not-for-profit, but generally speaking, you know, those kind of things are also options. You know, so you don't have to resort to, you know, the state being in charge or foster care for a minor or things like that. And then in Illinois, and this is something that Iowa doesn't have, and it's one of the best things about Illinois. If you're going to be a co-guardian, you must consent in Illinois to be co-guardians. I find this to be extremely helpful when in Iowa, I've got a couple of cases now where parents who are divorced and have a minor child who's disabled that turns 18, the parents insist on being co-guardians, and it can turn into disaster because they wouldn't have otherwise consented to be co-guardians. They didn't want to be co-guardians, but in Iowa, the court will generally prefer that for some reason. I don't really know why, and actually kind of force this situation upon these divorced parents. In Illinois, you must consent as co-guardians. If the co-guardians will not consent or shouldn't consent because they can't successfully co-parent or co-guardian, then the court will have a hearing, and it will be a contested hearing. And essentially the court, I hate to say it, but the court will choose sides at the end of the hearing. A lot of times the court will choose one person to be guardian of the person and one parent to be guardian of the estate, if that estate guardianship is necessary. But if not, then the court will determine, which one is appointed. So parents obviously need to be aware of that, but it's a good thing that parents who do not get along are not forced to co-guardian. It's not in the best interest of that. In my experience, it's not in the best interest of the ward. So that's something to keep in mind. Okay, moving along. So guardianship procedures, a lot of people want to know, what are the procedures? Guardianships vary greatly in how long they take, how expensive they are, what procedures can be skipped and what procedures must happen for it to be for a guardian to be legally appointed. So, number one, no matter what type of guardianship it is, with the exception of a 60-day temporary guardianship that we'll talk about it later, a petition needs to be filed. It's a petition for the appointment of either a limited or a plenary permanent guardianship. The petition, generally speaking, is pretty standard language. There's some language that has to be in there statutorily. And then there's language that, if you want to add in some additional background, you're obviously able to, and the court appreciates it. So, background on why the guardianship is necessary, that, obviously differs from family to family, from person to person. Who is the proposed guardian and who is the proposed ward? What are their names, ages, addresses, things like that. If you're applying for a guardian of the estate, the person's financial, the ward's, not the guardian's, but the ward's financial information must be disclosed. And then, of course, the physician's report needs to be attached. A petition is filed. Generally speaking, not generally speaking, in Illinois law, within 30 days, you must have a hearing. So the great thing about Illinois is that you should have, unless barring unforeseen circumstances such as a contested guardianship or something like that, you will have a guardianship in place within 30 days. Obviously there's exceptions, and that 30-day period can be extended by the court if there's reasoning to do so. But generally speaking, you're done within 30 days of filing that petition. Iowa can take a little longer. The reason Iowa can take a little longer is there's actually a 20-day mandatory wait period from the time that you serve that petition on the individual and hold that hearing. One thing that's interesting, a lot of parents don't understand, some parents have a big problem with, but it needs to be known, is that the petition needs to be served on the ward, and essentially by a process server. Now, if they get an attorney, that attorney can accept service on their behalf. But if there's really no attorney, or there's no need for a guardian ad litem, which in a lot of cases, if there's no need for one, you don't want one because it saves on attorney's fees or the fees to that guardian ad litem if they're not an attorney. But if there is no one to do that, or to accept service on their behalf, and the guardian or the parent cannot do that, by the way, then, even if it's a child, that child must be served by a process server. Strange, it's weird, it's uncomfortable. Process servers are the nicest people in the world, by the way. It's not like it is in the movies, but it's still it's a situation that a lot of parents don't want to have either their disabled child or the disabled adult to kind of go through, especially if it causes anxiety. But unfortunately, it's one of those procedural hurdles that has to be leapt. So in Illinois, it's very rare for a guardian ad litem to be waived. The statute requires it. A guardian ad litem, which is the eyes and ears of the court, the judge doesn't have the time, ability, or whatnot to, make a house call to the disabled individual's home or things like that, and determine whether or not the guardianship is in the best interest. Because that's the big question in the petition is this guardianship in the best interest of the ward? And so the court will almost always appoint a guardian ad litem who will interview the parents or current custodian of the individual, will interview if the person lives in a group home or person lives somewhere else, they'll interview who's in charge of that facility, you know, those kind of things. And then they'll write a report, they'll draft a report, and they'll file that with the court. And that report will have a conclusion as far as, is this in the best interest? Can it be limited? We talked about limited guardianships. Can this guardianship be limited? And if so, how can it be limited? Guardian ad litems can be waived if the case is abundantly clear. You know, my younger brother has Down syndrome. I just had a guardianship of a family where parents were becoming a guardian of their child with Down syndrome. And, you know, we asked the court for waiver of the GAL, and the judge here in Rock Island, Judge Thompson, approved the waiver of the guardian ad litem as long as the individual came into court for the hearing, which he did. And you know, Judge Thompson asked him a few questions, and it was obvious that he was disabled, and it was in the best interest. So the guardian ad litem was not required, but generally speaking, a guardian ad litem is going to be appointed. You will then have a hearing. Again, within those 30 days, you'll have a hearing. The proposed guardian and the ward must be present. The judge will and generally may ask, but generally does ask questions of both the guardian and the ward, just to kind of get a handle on, again, whether or not there can be a limited guardianship in place. And then the court enters an order on that day, generally speaking on that day. The exceptions to that are if there's a contested hearing. So if you've got two parents that can't decide who will be guardian, there will be an evidentiary hearing where each parent will get up and give testimony to the judge as to why they should be the appointed individual. In that case, generally speaking, the judge will not make a decision on that day. They will hold their decision and write write an opinion later on that will be filed and entered later. But again, generally they enter the order on that day, and then the clerk of court issues the letters of appointment. Letters of appointment are the most important thing for a guardian. It's got the stamp, it's got the seal, excuse me, from the court, and that is what you will use for the rest of the time you are guardian. You will take it to every hospital visit, every doctor's visit, every if they have an IEP or if they are continuing on with school, you'll give those letters of appointment to the school. You know, anywhere where a lifestyle decision is being made, you will need those letters of appointment. So it's important to get those. In Illinois, there is an online guardianship training that you must complete within a year of being, or 13, it might be 13 months, but generally a year, 13 months of being appointed. And so you just got to get online and go through that training. I think it's a video and maybe a slideshow, but pretty easy, you know, no big deal. And you've got a year to do it. So, and then you'll file annual reports with the court. And those are due also right around the time that your online guardianship training is due, and then every year thereafter. So, okay, so let's get into a couple of other kind of guardianship, different types of guardianships, I guess you could say. So standby guardianship, we haven't really talked about standby guardianships yet. There's a wide variety of these standby guardianships, all of which can be considered a quote unquote standby guardianships, but they're kind of different in how they, how you either get them or appoint somebody, things like that. So in general, a standby guardianship, no matter what type of standby guardianship, is a designation by the guardian of the person in writing. Okay, so it has to be in writing, and it always has to be signed by two witnesses. So the first type of a standby guardianship is one that individuals, guardians will put into their will. So somebody who's already a guardian, in this case, a parent can do this too, but who's already a guardian can put in their will, last will and testament, a nomination of who is going to serve as the next guardian. So that in and of itself a will is always by the will. If you've never signed a will is always in writing and it's always signed by two witnesses. So it already meets the criteria and requirement of a statutory standby guardianship. And so in that last will and testament, you put a nomination of who will be guardian. At that point in time, that individual is a standby guardian. One good thing to note here is that when possible, that guardian must discuss with the ward. Again, this goes into the rights of the ward. What rights does the ward have? Well, the ward still maintains their right to be heard on who is going to be the standby guardianship, who is going to be the successor guardian, decisions like that. But if the ward has the ability to participate in that decision making, the guardian should and must allow them to at least have a say. Now, if their decision is their favorite uncle who lives in Alaska and is not going to move back, or lives in Alaska and maybe isn't responsible enough to be guardian, that's one thing, and that's where the guardian's decision will override any decision made by the ward, because it does need to be in the best interest, and maybe a decision like that isn't in the best interest. But generally speaking, you need to have that conversation with the ward. And then to get a standby guardianship, eventually a standby guardianship has to be approved by the court. So either one, you have a writing saying, I appoint this individual, signed by two witnesses, I appoint this individual as standby guardianship. You can file that with the court. And then when an event triggers or happens, then you have a hearing with the cut. Everything's already filed with the court, and you have a hearing with the court when it's necessary to have that standby guardian appointed, or you put it into your will and testament, and then upon the parent's passing, then you file a normal petition like we just talked about and go through those normal procedures. So these types of standby guardianships do not skip the procedures that we just talked about, but they do smooth the way. It does kind of act as a rubber stamp. The court will take a standby guardianship or a nomination in a will, and generally speaking, abide by the wishes of those individuals who nominated those standby guardians. Excuse me. So it's a good idea to get a standby guardianship in place, because upon your disability or your passing as the guardian, you can have peace of mind that that process will not necessarily be as rocky or as elongated as it would be if you were starting from scratch. And there wouldn't be the possibility of 3 or 4 people fighting to become guardian for their loved one. You as the parent have already named somebody. So you do have to follow those court procedures, and then when you file a standby guardianship, you need to have. You can file one and it can sit there for a while, but if it's going to be, you are an active guardian for 60 days, but it expires after that. So if you don't get that permanent guardianship within 60 days, your powers as a temporary standby guardian go away. So, if you're filing a standby guardianship around the time you're going to need it, just know that you really need to get authorized to act in a permanent way within 60 days.
The responsibilities are still the same during that.
Correct. Yes, absolutely. You still have the same responsibilities. That's right. Testamentary guardianship, we kind of already talked about this. You can put it within your last will and testament. You can put it in your power of attorney document. Most powers of attorney are for your guardian. So if you, as the guardian, do a power of attorney, appointing somebody as power of attorney, a lot of times all the time, I guess, that power of attorney will also allow you the ability to name an individual to be your guardian should you become disabled. And that becomes that's essentially a standby guardianship, just an unfiled standby guardianship. And then, upon parent's death, kind of talked about that. And this is just, you're not being appointed yet without the ability or without the requirement to be appointed yet. Short-term guardianship. Okay, there is one type of guardianship that is short-term and does not require court intervention. So one example is that if parents are going on a European vacation for 30 or 60 days and their child's in school, and the child is going to stay with an aunt and uncle down the street, and their cousins, then the parents can actually sign, again, designated in writing by the guardian with 2 witnesses, and they can effectively grant them those guardian/parental rights for up to 60 days. And it's 60 days within a 12-month period. So you can do it multiple times, but you can't do it for more than 60 days in a 12-month period. And those are perfectly valid. Those documents that are signed by the guardian and witnessed by 2 individuals, perfectly valid. Again, it can be used almost like the letters of appointment from a court. If the aunt and uncle that have been provided that power or responsibility has those documents, the school will accept them, the hospitals and doctors and everybody will accept them. So if there's some kind of catastrophe, medical-wise, those papers are effective for that 60 days. Okay, well, I did leave some time for questions. I'm not sure do I have any questions?
Thank you for your time. It was really informative. The reason I'm inquiring is because I had done exactly what you had talked about prior to my son turning 18, and he's now going to be 22 in January. Mm-hmm. And he was denied last year we were denied for assistance from the state last year because he has multiple things going on. He's got, clinical depression, and then he is also on the spectrum. And had him reevaluated this year, and he's on the spectrum. And so, but anyway, prior to that, I had inquired with an attorney about the process of guardianship, disability and things like that. And it was different at that weight was 25 until he was allowed to have a little bit to see if, he could function on his own. Okay. He's now going to be 22. He is now, so like for a lot of, my other children, they had their first job teen, and he just got his first job, and it's part-time. And so, the ultimate thing, like with all of this stuff, when I'm no longer here, because I am a single parent, father's not in the picture, worried about strain on my daughters, to help them. And viably, of course, him being able to live on his own, because I even have to recourse for his medicine every day still. I mean, everything, but yet it's determined far that he's not quote unquote enough, and so, what do us gray area parents?
Yeah. Oh, yeah. Great. Great question. And obviously a unique scenario. It's unfortunate that, so have you ever gone to a doctor to try to get it? Obviously he's been like you said, he's been diagnosed to be on the spectrum. Will a doctor, generally speaking, a doctor, in a case like yours where you're pretty much doing everything for him and you have that conversation with the doctor, have your doctors or his doctors refused to put in writing that a guardianship is necessary? Because a lot of times the physician's report that you get, say this individual is on the spectrum or whatever the disability is, and then a guardianship is necessary. Will a doctor not do that?
No, I think that's probably the piece that's missing, what you just said, because through this whole journey, we've had all kinds of documentation and everything else, but I don't believe they've ever specifically cited the guardianship word in there. They've just, in
Yep.
fact said, they're recommending that we, get him get help, because the financial burden alone, I work 4 jobs just to,
Yep.
meet.
Yep. Yeah. So in Illinois, there's actually a statutory form for the physician's report. So Illinois is
Okay.
very form based on things like this. And if you emailed me, my email address I can put back up there, but I could send you that statutory form. You could also probably Google it. But if you wanted to email me, I'd be happy to send you the statutory form. But basically, it's a very simple form, and it's got a bunch of blanks, and you put who your son's name is and who the doctor is, and then the doctor will complete basically the diagnosis. There's a bunch of blank lines where the doctor complete the diagnosis, and then there's a check mark that says guardianship is necessary, guardianship is not necessary, and they would just check guardianship is necessary and then sign it. They can obviously do their own letters. A lot of doctors prefer to put it in their own letterhead or whatever, and that's perfectly acceptable. But you can also have a doctor sign a statutory form, and that's what you use when you file the petition. You file this physician's report stating that a guardianship is necessary. And generally speaking, I guess I didn't talk about that. I'm glad you brought it up. That physician's report, to get a guardianship in place, generally speaking, that a physician's report is required to state that the doctor feels that a guardian is necessary. I don't want to speak for government benefits. I don't pretend, I don't know what's in the mind of DHS or wherever you're applying. But in my opinion, they would have a much harder time denying coverage or denying benefits if you're able to get that guardianship in place. And the key to getting that guardianship in place is to get a doctor to both diagnose and declare that a guardianship is necessary.
Oh, so much for that information. I do that. I think that's for us. I think that's our missing link.
Sure.
Potentially. I would appreciate that, with that, because I've had multiple doctors write letters and things like that. But, we've not been able to obtain any help. So.
Right. Yeah. I'm not promising any magic bullets, but it's certainly a step that hasn't been taken, and I would think would go a long way, and probably is the key to it. But I guess you'd have to go through the process to find out. But
yeah, so I have to leave this meeting at the time. But if I could get your email, I would really appreciate that.
You bet. Can you see? Well, let's see. Am I sharing anymore? Can you see that? Oh wait, it's not on that slide.
Yeah.
Hang on. Sorry. Let me get it up here. There you go. And that is my email, and then that's my direct line to my desk. So either if I'm at my desk, I'll answer it. If I'm not, it'll go to my voicemail, and I'll return your call. So that's you're not going to be screened.
I'm sorry, it's not. I'm still.
It's not showing. Oh, I'm not.
Yeah.
Sorry, I'm not showing anymore.
It's okay.
Okay, was I
or
sharing
even
the
if
whole,
you
was I
wanted
not
to
sharing the whole
email
time?
me.
Oh, I wasn't even sharing the whole time.
With you?
I don't think so. Whoops. Sorry, Sue.
Okay.
I will send you the presentation. So can you see it now, Kelly?
I can, yes.
Okay, so yeah, there you go. And I apologize, everybody who's watching this on on tape delay. I'll make sure that my slides are sent to Sue, and you can post those probably, right? Okay, so my slides will be posted for those of you who listen to this later. But yeah, Kelly, there's my email address. Please feel free to contact me.
Okay, thank you so much. I appreciate your time tonight, and I'm happy, but yeah, get back to work. So I appreciate your time.
Absolutely, yeah, you bet. Thank you, Kelly.
Bye-bye.
Bye. Okay, I think that's it. Everybody's got my contact information now, so I will log off unless you had something else.
We do have, that's my flyer, we have a town hall type meeting coming up. And that is through the Arc of Illinois. And what they want to do is hear people's stories, know what people are needing so they can better advocate on your behalf. And that will be November 13th from 6 to 7:30. It'll be held at Black Hawk Special Education Center. If you're interested, go ahead and email me, and I would love to get this flyer out to you.
Okay, awesome. All right, well, thank you, everyone, and I'll talk to you soon.